Judge was telling folks there to take a bit of a break this afternoon, so we're going to jump in with some more analysis. Julie Rendelman is a law and crime trial analyst. She's here with me in studio. Julie, it's been a little while since we've argued with one another here, so what do you make of this? Real back and forth here.
Yeah, I mean, it's not uncommon for there to be a redirect, recross. The judge can step in and say, we're done.
Yeah, this was turning into a ping pong match.
Yeah, and
the topics were circular. We were
well,
looping
it's all about
back
the same
around.
issue, but that happens to be probably the most important issue, which is who had control of that phone. And so that's why I think both sides are harping on it so much. And so that, you know, although it seems like the same question is being asked again and again.
Yeah, not only that, I took it just as an attempt by the defense to try to discredit what this guy was saying, because it's pretty clear that he wants to make the prosecutor happy. He admitted so much. It was clear before he even admitted to it. So does this witness just have reason to get up on the stand and basically just say, oh, yes, Mr. Prosecutor, yes, that's exactly the way it happened, regardless of what the truth is? He does
and he doesn't, yes. I think at the end of the day, and this is what we were talking about earlier, is that I think the issue for the jury is not, I think the jury's going to probably know that he's not the most truthful guy, and there's going to be questions as to whether or not you can rely on him. At the end of the day, though, is do you believe him when he says that he was present when this murder happened? Some jurors may not, but they will still believe that the defendant either acted on his own or acted in concert with this guy. And so if they do that, then I still think that they can find him guilty of the murder.
Yeah, look, let's keep a close eye on this really interesting case out of Wisconsin. Again, Daniel Tate, we're calling it the so-called murder on the beach case. Julie, it's a tricky case because when you've got two people who are accused of being a party to a crime, to use Wisconsin's language, in various fashions, you've got one on the stand saying, oh, yeah, you know, the other guy did all the major stuff. And we see this theme repeating time and time again in these cases. And sometimes we get done listening to the testimony, and I'm sitting here saying, okay, which one of them really did most of it and which of them really didn't? Did they both do the same amount? Should they both be theoretically held just as culpable as the other and whatnot? You know, and of course the witness is saying, hey, look, I'm doing this because I want leniency.
Sure.
And it turns into a head scratcher as to exactly who really did what.
It's true, and I think the prosecutor, you know, has an uphill battle, but I also think it's for the prosecutor to explain to the jury that when you have a case in which the only potential witnesses are the victim, who's now dead and so can't speak from the grave, and one of the co-defendants, then what you do in order to get the bigger fish is go after the smaller fish. As to whether or not the jury can kind of separate the two as to which one's the more culpable, I think that's where the prosecution won, although I don't know as to whether they won fully in terms of an appeal, is they were able to get in the evidence that the defendant Tate had been involved in separate incidents of which he had wanted consensual sex that involved strangulation. And so getting that in, I think, was huge for the prosecution. I think there's an appeal issue that exists there, but I think that is probably what's going to get the jury believing that it's Tate versus this guy.
Well, you know, I was trying to figure out where they were going with that strangulation sexual urge argument. Are they trying to turn around and say that there was no intent here? Because they need to prove intent, saying, hey, look, the only thing he really was trying to do is play out this sort of weird sexual fantasy.
I think they're doing what you're not supposed to do, which is getting in prior bad acts of the defendant to prove that the defendant is a bad guy. Because I don't really see how having consensual sex with a woman of which there's consensual strangulation or consensual, you know, that kind of sadomasochistic or aggressive sexual relationship in any way relates to luring a woman, you know, out to a location where he dunks her and strangles her.
Yeah,
there's no indication that there was a sexual act.
The head in the water in the lake sounds a little bit different from
the two have nothing to do with each other. So I think it's the prosecution. You know, so we were talking, Mr. Bianchi and I were talking earlier about the fact sometimes as prosecutors we don't push for too much because we don't want an appeal. I think the prosecutor was so worried that they wouldn't buy just what this witness was saying that they needed something else to push it over the edge.
Well, we're going to keep an eye on that case in Wisconsin, which should be continuing at some point after an afternoon break wraps up. In the meantime, we're going to switch over to the Kwame Richardson and Henry Hayes case out of Florida. This is a case involving the death of a 22-month-old toddler named Aiden McClendon. The accusation in this case is that the two defendants were launching a gang attack on a relative of that 22-month-old child, and that the 22-month-old was shot in the crossfire. There is a detective in violent crimes on the stand in that case right now, so we're going to listen in there for just a little while. Interesting video there in the Richardson and Hayes case out of Florida, where a 22-month-old named Aiden McClendon was caught in the crossfire in what's alleged by prosecutors to be a gang-related attack. Julie Rendelman, we just watched the recording there, surveillance video of the area where this went down, a couple of different angles. These surveillance cameras are everywhere these days. They're inexpensive, they record a lot, and then one of the first things police do is go looking around the area trying to figure out what they can show. And here we've got this sequence that's movie made showing the alleged defendant's vehicle going around the neighborhood, approaching the scene, showing up at the scene, and then the bullets being fired, puffs of debris flying off of a building, people hitting the ground, trying to duck themselves, and then the vehicle that the victim is in kind of like hitting the curb. And we heard testimony about why the vehicle's tire was shredded in the process of this. You know, this is the sort of visual stuff that really brings it home to juries, and it's always a surprise to me just how quickly these things happen.
Yeah, I mean, look, you know, anytime we're dealing with these gang cases where there's, you know, kind of the evidence of two gangs, you know, shooting or creating a dangerous environment of which someone's potentially going to get killed when they're in the crossfire, are, you know, incredibly difficult for the prosecution because you're really trying to focus on both sides and trying to prove the case from both sides. And you're absolutely right. I think, you know, years ago, we didn't have the cameras that we look at right now every time. You know, the minute you get a case, whether you're a prosecutor or defense attorney, the first thing you ask is there a camera there? Where's that camera? What's it going to show? And we talk about that with cell phones as well, GPS, cell site, all these things have really changed the dynamics, not just for the prosecution, but for the defense. And I think in this case, it's going to help the prosecution a whole lot in making out their case.
Yeah, I think we've got another witness on the stand in the Kwame Richardson Henry Hayes case in Florida. The victim, a 22-month-old child. We're going to go there. Keep in mind, we're still monitoring the Daniel Tate case in Wisconsin. We'll go there as soon as a break wraps up. Could be a huge development in the case we're following out of Wisconsin, the case involving the death of a 17-year-old who was choked and who had her head put underwater in Lake Michigan. This is the Tate case, the Daniel Tate case. We're calling it the murder on the beach case. And look, this is what's going on right now. Accusations from multiple people that jurors are potentially discussing the case in the bathroom, in the hallways, in the midst of breaks, and apparently the power was out for a little while in the courthouse, and some of these discussions may have been going on then. We had a daughter and a mother up on the stand trying to answer questions about it. This could be a huge thing. This could shut this trial down because obviously jurors are told you cannot jumpstart deliberations in the middle of a trial. That's the rule everywhere, and they are warned up and down, left and right, usually multiple times a day, usually before every single break, that they can't do it. So if that's what's going on here, this is a big problem. Julie Rendelman is Law and Crime trial analyst. Julie, what do you make of this?
Well, I think the second comments that were made are a little more innocuous than the first. We don't know if they're talking about the case. We don't know if someone's annoying them. That has absolutely nothing to do with this case. This is more her complaining about putting an end to something. I'm not sure how she would potentially put an end to a trial, so I'm not sure that.
Yeah, but I get that. But I get, you know, when I was on a jury and when I've been in front of other judges, they've said I want nothing more than sort of polite nods to one another and absolutely no more words crossing your lips.
Not true at all. People.
Yeah, that's what I've been told.
I've never heard that. The only thing I've ever heard is that jurors cannot discuss the case. Period. They can discuss anything but the case. These jurors are sometimes together for 2 weeks, 3 weeks, 4 weeks. Of course they're going to have conversations. Many of the jurors get to know each other. So that to me is not an issue. The issue really is, especially in the first situation, that clearly jurors are now pontificating on how they're going to get jurors to come on their side. Now, as a prosecution and defense, the problem is neither side knows which side they're going with. And so, you know, the prosecutor, obviously, if you're the prosecutor and you knew they were on your side, you're going to be more inclined to want to keep them.
Yeah, but okay. So look, I mean, I've been involved in cases in some pretty small courtrooms where judges are more worried about these sort of you know, side conversations starting to veer in the wrong direction. So that's why some of the judges that I've been around have said, this is a small facility. I don't want to get reports that you're talking about the weather, and then that leads to the weather that happened on the date that's part of the incident. And then he said these conversations can spin out of control very quickly, and it's a small facility. So just don't go there. Anyway.
But the issue is whether or not this is going to end the case or cause a mistrial. And so when two individuals, look, this person knows who these people are, so potentially these jurors will take the stand and be questioned by the judge as to what they meant by what they said and to instruct them not to discuss it further. I think the bigger issue is the first two women talking.
They're getting us on their side.
Exactly.
Sounds like there's already jockeying going on.
Exactly.
And this is just one little symptom of a bigger malaise, malady, whatever you want to call it. And that they're already sort of like, entrenching themselves into camps on this jury.
And I think, and this doesn't help the situation, but one of the things the judge is saying is, why are the jurors even in close proximity to where potential witnesses and potential spectators are? There's a jury room with a jury bathroom. So I'm not, look, in a sense, one would say, oh, thank God they were, so someone could hear what was happening and call them out on it. But the truth is that they shouldn't even be in a situation where they're running into each other and potentially hearing each other's conversation on top of it.
Yeah, I mean, one of the questions the judge had is, okay, look, I got to ask the bailiff who's being allowed out of the room at the same time and all these other questions. That's a sort of a security management question. We understand that what's happening in court right now is they're trying to figure out if they want to question another person. So we're keeping a very close eye on that. The next question is, what is the law in this jurisdiction about mistrials, and is this enough to reach one here?
I don't know what the specific law is in this state, and again, I'm not sure that what has happened necessarily rises to the level of mistrial. Again, I don't know that we haven't gotten to the bottom of it. We don't know who the jurors are, and remember, there was one juror, at least in the first situation, who appeared to have said either we or I, in terms of either we need to get them on our side or I need to get them on my side, of which the other individual didn't respond. So we may just be talking about one juror. It's unclear. And I think that before we even get to the idea of, starting this trial over, I think the judge has to get to the bottom of what these individuals were saying, who it was, and what they meant by it. And see if there's a way to keep this case going. Yeah,
I mean, obviously judges like to keep the ball rolling here, but sometimes don't judges do that at the detriment of one of the parties? Because look, just trying to say, oh, jurors, I told you not to do this, and then you did it, but I'm going to keep the ball rolling just out of the efficiency quotient of not having to drag everything back out again. But look, jurors are told not to do this for a very specific reason. Right,
and yes, there's always a concern of an appeal issue. Keep in mind, depending on where you sit, the defense attorney and the prosecutor are likely going to have a role in this decision-making also, because they're going to voice their opinions as to whether to keep this case going. They're not the decider. And so the defense may believe that their case is going really well. They may believe that the witness that took the stand hurt the prosecution. They may go, oh, let's keep this going. The prosecution we don't know, everyone has skin in the game. So, simply because jurors are talking, and remember, one side or the other may think, oh, I think that's the juror that likes me. So everyone it's not just about what the juror said, it's also kind of how they think this case is going for either side.
Yeah, I mean, if the case looks like it's going well for you, then you might want to try to keep the ball rolling along down the line and everything. But, what's the actual law say about it? It's been a long time since I've dug it up in Wisconsin.
I don't know what it is in Wisconsin. I know that, you're not allowed to speak. It's not a done deal that simply because you've had conversations, that means that you can't, continue on a case. It depends on whether or not a juror has formed an opinion about the outcome of the case.
Well, I mean, from the statement that we had here, it seems pretty clear that there is a side.
But we're not up to that yet, though, because now we have a potential witness who can't even identify the individuals that
or
made
doesn't
this statement,
want to. It sounds to me like doesn't want to get anybody in trouble.
Okay, but at the end of the day, we have to also decide how credible this witness is and whether or not this witness actually heard what she said. And that's why you need to call the potential jurors up there to find out what they said, what they meant, and if it really has value to impacting whether or not this defendant can get a fair trial.
You said at one point that there's an easy way to try to get out of some of the questions here, and that is bring the jurors in one by one and ask people, who did you
Right.
You know, what did you say?
Were you in the bathroom or were you not in the bathroom? I mean, obviously we can cut it down because it's only females that are in that bathroom. So now we've removed part of the population of the jury. We also know that the other witness can identify at least 2 of the individuals, and we know that that female is not one of the 2 that was talking in the bathroom. So now we've eliminated another. It's not complicated to get to the bottom of this. I think the bigger issue is not just if those 2 are talking or the 2 that were smoking are talking. It's, is this kind of a problem for the entire jury that they're already making up their minds before this case is finished?
You know, I was initially listening to this and thinking, okay, look, there's this comment in the bathroom, there's a comment of annoyance in the stairwell, I'll put an end to it. And I was thinking, do these have nothing to do with one another? But the thought just crossed my mind, maybe they do. Maybe some jurors know that the other ones are trying to, like, entrench into camps, and that the juror who was complaining about the other ones.
Right, and this is what, I mean, this is what analysis is about, where we're just purely guessing about what's happening, you know, and I don't know that we'll know at this point.
We're going to go to a quick break here, and we will be right back with more, waiting to see what happens in the Daniel Tate case in Wisconsin, the case of a 20-year-old defendant in a so-called murder on the beach case. We've got an issue popping up in court right now, a big question as to whether or not the jury has sort of jump-started deliberation in the middle of the case. The judge asking people who overheard things in a bathroom and in a stairwell to recount what they heard. We're going to wait and see how the arguments go in this and whether or not individual jurors are being questioned. We'll be back in a second. Questioning of that key witness has not picked up yet. It looked like he was nodding his head and was about to start saying something. But look, we've got the bailiffs talking to the judge. The judge said he needs to get to the bottom of exactly when these jurors are leaving the room. Julie Rendelman, law and crime trial analyst, attorney here in New York City. What is going on with this situation? You've got this guy up here saying, oh, these other 2 people are liars. And it's like, is this like a character trial about the people who claimed that they heard the jurors talking?
I think this is going to be a trial within a trial, and now we'll have jurors chosen to make a determination as to whether the 2 women who heard them talking are credible or not. I think that, I mean, I'm being sarcastic, but I have to be honest, I'm not sure why now the judge is bringing the witness back on the stand when we haven't resolved whether or not there's jurors potentially discussing this case. And
I was under the impression that the witness was making some kind of a proffer or something outside the presence of the jury, and that then this information came in the midst of it, because there was this break when they said no further questions, and then this guy was back up on the stand for like a split second, and then they stopped.
I'm not following it, but I would say I don't understand why the potential witness is on the stand when there's much more pending and important matters, i.e. whether or not you have a juror that can be fair and impartial on this case. And the last thing I want as a prosecutor is to have a witness potentially testifying to additional evidence that if there's another trial, they can use that potential testimony as fodder for the defense to cross-examine him on. So there's kind of priorities, and the first priority is to figure out what's going on with this jury.
Well, it sounded like they wanted to hold that until tomorrow, and then it's like, why not get to the bottom of it here, and why not get the jurors up there and start asking them, were you in the bathroom downstairs, which is what you were suggesting.
Right, especially since that it's today, so we want to get the jurors' best recollection of where they were. You know, I mean, I hate to say it, but people forget things, especially what time they were in the bathroom. So get it done and prioritize what's relevant, which is whether or not you have a fair and impartial jury at this point.
Yeah, I mean, what's the deal with this guy getting up there saying, oh, I've had business dealings with these 2 who made the accusation, and I think that they're both liars? Like, Aaron, where did that come from? What is the point of that?
I've never in my career ever seen anything like that. Nor do I think at the end of the day it really matters. The only issue, and by the way, keep in mind the witnesses, the women that overheard this, they're not saying that the various jurors were saying specific things as to the case. So if they wanted to lie, they would have been very clear that the jurors were taking specific positions about the guilt or innocence. So I don't know why the judge is wasting our time, and everyone else's time finding out whether or not these people are liars. Get the jurors on the witness stand and find out what transpired, period.
Yeah, I mean, I really want to know what Wisconsin law says about this. I'm going to try to look that up, but we've got some more action in court, so let's cut back again to the Daniel Tate case in Wisconsin. Okay, the end of the day there, I was wondering if the judge was going to admonish the jurors not to talk about the case, or if he was going to sort of backslide into what was being discussed outside the jurors' presence, but I didn't get a chance to listen to it. Julie Rendelman, this has caused a disruption here, but then we had this cross-examination about this other line of questions, and it sounds like the officers who were asking the questions were just throwing questions at this particular witness and not really giving him a chance to fully answer, or he just wasn't answering some of the questions, and somebody needed to clean that up.
Yeah, I don't, sometimes the prosecutor can clean it up a little too much. I mean, the witness is responsible for the witness's answers, and so you can't constantly blame every lie or every misrepresentation on the individuals asking the questions. There are limits to the excuses, but yes, he did a fine job of at least attempting to clean it up.
What do we make of this issue about these jurors here? And apparently the judge wants to try to take this up sometime tomorrow, sometime later. You've got this accusation that jurors are talking about the case, talking about getting people into various camps and everything, getting one side against another side. That's the accusation. Then you've got this other guy getting up there and saying, those two who are making the accusation are known liars to me. I've never seen anything like it. You haven't either.
But I'm enjoying it.
Well, I'm glad you are. I get nervous when I hear these kind of accusations. It's like, okay, who's telling the truth? How does this need to be cleaned up? What's the cure? Is the cure to admonish people? Is the cure to, throw people off the jury and bring in alternates? How does the judge deal with it?
Well, the cure is, I think, is to find out what exactly is going on with his jurors and what's being discussed, so that the defense and the prosecution have an opportunity to fully understand what's going on, outside of their presence. And then once they know that, to make a decision, A, whether those jurors are telling the truth about what was discussed, and B, whether what they discussed, obviously we know it broke the rule of discussing things, but does it indicate that they're not going to be able to go forward in regards to being fair and impartial jurors with regards to this case?
Nobody should want to anger the judge in a case like this, but I'm curious about the answer to those questions. So, Julie Rendelman, Law and Crime trial analyst, appreciate you being here today.
Thank you so much.
All right, we're going to wrap up the broadcast for the day.